It's a pleasure to welcome Dr. Pierson from Frankfurt, as I heard, at the University of Frankfurt. And I shortly introduce him, and then I will give him the floor to give his paper. Thomas Pierson studied law as well as history and political sciences. Politikwissenschaften, no? Mm-hmm. Yeah. In Frankfurt, both in Frankfurt. And he holds a title as Magister Artium, a doctor in law. His main research interests lay in the field of legal history. He is historian and jurist, so he's legal historian, especially in the history of employment and employment contracts. He published 2 books and several articles on the history of employment law in a wide range. His first book is about hands and servants in the household, and the second investigates the legal position of servants using archival material from the 14th through to the 18th century, especially in Frankfurt. Thomas Pierson is one of the few German legal historians who are interested in the history of employment contracts and the legal construction of asymmetrical dependencies. Therefore, we really appreciate his visit to Bonn, and we all are interested in his talk on legal asymmetries and dependencies in German civil service relations since the late Middle Ages. Thank you again. The floor is yours, please, Mr. Pierson.
Thank you very much for the invitation and the very kind introduction. I have, of course, been thinking about this forum, and my topic is probably a bit out of the ordinary. For understandable reasons, civil servants are not at the center of considerations when we think of strong asymmetrical dependencies. In the following, I would like to use the German example to show why such a perspective is perhaps nevertheless worthwhile with regards to the questions of the center. I will therefore start by explaining my theoretical starting point and, with reference to a current case example, present a legal concept that can show the connection between my object of study and your research approaches. I will then present various individual aspects, in particular on the question of the fair wage, on the problem of freedom, and on the chance of protest as a sign of strong dependencies. As a legal scholar, I'm concerned with the concrete solution of legal problems, and as a legal historian with their solution in the past. Work for lawyers arises in cases of ambiguity. In this respect, it is obvious that jurists have been working in the field beyond the dichotomy of freedom and slavery for decades. Thomas Dube has already made an instructive contribution to this, so I do not need to repeat it. Nevertheless, I will provide a working definition of asymmetrical dependency for the purposes of my further remarks. In my review, it concerns the creation or perpetuation of one-sided ties through the unequal distribution of rights and duties in the employment relationship, which is characterized in particular by the fact that the tie goes beyond the exchange relationship of performance and consideration, work for remuneration. Examples would be unequal contract termination regimes or the employee's arrogation of a right of this direction outside of work or working hours, it as encroachment on private life. The German civil service is a special case in European comparison and probably beyond. Nevertheless, beyond the German case, the civil service has specific characteristics that distinguish civil servants from other groups of employees. People talk about the special closeness of civil servants to the state, which is supposed to entail modified rights and duties. This is certainly true, but the idea can be defined more precisely. I have elsewhere called this the disciplining of disciplinary agents following the research concept of early modern social disciplining. And this formulation emphasizes the dual role of the civil servants, who on the one hand are themselves the subject of disciplining as acting persons, but on the other hand are also its object. Their active role secured them a position of power, which even under the pressure of the early modern public was to be contained by strong ties. These were predominantly set unilaterally, therefore unequally, which is why a legal network emerged that can possibly be translated as strong asymmetrical dependence. Disciplinary law per se, of course, with sorts of modifications such as judicial control, has survived through the day. With this anomaly in the legal system, off-duty behavior can in principle also be sanctioned. Let me start with a very recent case that has caused quite a furor in the press and in the public in the past few weeks. Perhaps it would be better to speak of popular outrage. It is about a judgment of the German Supreme Court, the Federal Administrative Court, which also serves as appellate court for the military service jurisdiction. The court interfered with the private and intimate sphere of a female officer by upholding a disciplinary measure. In this respect, the legal assessments and concepts affect civil servants and soldiers equally. Disciplinary proceedings presumably only came about because the person concerned, Anastasia Bifang, had achieved a certain degree of notoriety as a transsexual battalion commander with the rank of lieutenant colonel. Her disciplinary offense consisted of tindering, using her first name but without reference to the Bundeswehr, with a harmless profile picture and a somewhat explicit text. Especially, she wrote, "Spontaneous, lustful trans, open relationship looking for sex, all genders welcome." According to court's press release, the court relied on the off-duty obligation of good conduct, which requires consideration for a professional position in the choice of words and images used on the internet. Bifang therefore had to avoid wording that gave the false impression of an indiscriminate sex life and a significant lack of integrity of character. The words open relationship, looking for sex, all genders welcome, also cast doubt on the commander's required integrity of character from the perspective of a reasonable observer. The court decision, the exact wording of which is still unpublished, led to frantic activity by soldiers of all genders and sexual orientations who anonymized their pictures and deleted reference to the Bundeswehr, which had previously even gone unobjected. The letter also triggered suspicions of discrimination in the trade press, but that's another theme. In any case, those affected renounce the exercise of their fundamental rights, which can be described as a so-called chilling effect, a form of deterrence. Whether the Federal Constitutional Court will still have to decide on a correction of this decision remains to be seen. My concern is something else. Such interventions require a special justification. Until recently, the legitimizing legal concept was a so-called besonderes Gewaltverhältnis. I don't know whether there is a 100% suitable translation for this. The Federal Constitutional Court itself translates the term as special relationship of subordination. Fittingly, the term dates back to the 19th century. As far as is known, the professor of constitutional law, Paul Laband, first described the special duty of obedience, loyalty, and responsibilities of civil servants as a Gewaltverhältnis in 1876, in the first volume of his famous Staatsrecht des Deutschen Reiches, Constitutional Law of the German Empire. However, Otto Meyer is considered to be the real creator of the legal concept in his Deutsches Verwaltungsrecht, German administrative law, who in 1895 still understood the special relationship of subordination as a legal one. But from the second edition of 1914 onwards, defined as an aggravated dependency, which is established for the benefit of a certain purpose of public administration for all individuals who enter into a special relationship. The relationship is now no longer two-sided, but only works against a person subjected to subordination, who is also referred to as Untertan subject. Although a theoretical creation of the German Empire, the roots of this understanding are traced back to the ancient Germanic ideas of allegiance. Even though such master narratives are hard to prove historically consistent, it is of interest insofar as these particular duties of obedience and loyalty can be traced consistently across the Middle Ages and early modern period in the corresponding service contracts and orders. I have brought here my quantitative results for the occurrence in the service contracts of the Free Imperial City of Frankfurt. The aggravated dependency in Meyer's sense only inadequately outlines the originally dramatic legal consequences that accompanied the closeness to the state created by entering the civil service relationship. The prevailing impermeability theory at this time stated that no legal relations were possible within a legal entity under public law, lawless space. And therefore, measures in the special relationship of subordination were withdrawn from judicial control as juridically free acts of sovereignty. Similar arguments were made with regard to the fiction of a renunciation of fundamental rights when entering in the sphere of the state. The term special relation of subordination is rarely used today. One prefers to speak rather vaguely of special legal relationship or special status relationship in order to avoid these associations. In fact, since a decision by the Federal Constitutional Court in 1972, fundamental rights also apply in special relationships of subordination. Nevertheless, the reformulation obscures the problems without really overcoming the solutions. The Tinder ruling of the Federal Administrative Court is merely a symptom because disciplinary law and duties of conduct continue to apply in principle. In the dictation of the 1972 prisoner ruling, this means that the fundamental rights should apply in principle, but they can be restricted insofar as the purpose of the special relationship of subordination in question requires it. By placing the validity of fundamental rights under the reservation of the purpose of the legal relationship, limiting them, it ultimately remains ineffective in the critical cases, because it is dependent on the instances determining the purpose. Of course, this was already a great step forward. The Tinder ruling demonstrates the shortlessness of the reservation, although the Federal Court of Administration even corrected the previous court's even harsher formulations with regard to the scope of the application of the fundamental rights. The use of the concept of a special relationship of subordination for this lecture can also be justified by the groups covered. In addition to the employment relationship of civil servants and soldiers, it also covers the educational relationship of pupils and students, the prison relationship, and until its suspension, the compulsory military service relationship. With prisoners, a group is subjected to the legal concept whose type of work is already in the focus of the center. Special pupil and student employment relationships do not exist, but the mention nevertheless evokes associations outside the sphere of the state. It would be interesting to examine apprenticeship and training relationships. In German law, the Gewerbeordnung, Trade, Commerce and Industry Regulation Act still had an explicit right to chastise it as a competence to corporal punishment. It was not until an amendment to the Industrial Code in 1951 that this was finally prohibited. In 1957, the Federal Court of Justice still granted teachers the right to corporal punishment according to general customary law. The judges did not recognize a violation of human dignity or the right of bodily integrity, or they recognized in customary law a sufficient legal basis for the violation. The court did not consider a Hessian ministerial order prohibiting corporal punishment to be a sufficient legal quality. The ban on corporal punishment only disappeared from schools in the 1970s, most recently in Bavaria in 1982. With regard to the question of strong asymmetrical independence, and the permanence of these relationships is partly lacking. But historically, for example, the Gesindeverhältnis, a servant relationship, was also often a life stage experience and temporary preparation for the management of their own household for certain classes of the population. Incidentally, the explicit right of chastisement that existed in the case of apprentices and pupils lasted much longer than in the case of servants. And there, for example, corporal punishment had already been prohibited by the Prussian Gesindeordnung, servant regulations of 1810. All that remained was the residue of a limited reason for excluding punishment, which left the servants the right of self-defense. In short, apprentices would be an interesting field of study, and at last, in terms of legal historian research desideratum. Instead of further definitions of terms, associations, and levels of comparison, I would now like to concentrate on the core of the subject of the lecture and attempt some deep historical drilling into the history of the civil service. As far as I can see, the main problems and solutions in the civil service reflect the cluster's thesis on the characteristics of asymmetric dependency. For example, control of one actor over the others, access to resources, and the institutionalized attempt to deprive the other actor of exit and protest opportunities. Both wake-setting mechanisms and wake structures can be an expression of asymmetrical dependency and can themselves establish or promote such one. In the late Middle Ages and into the early modern period, wages in the public service were largely freely and individually negotiated. In the sovereign sphere, corporatist ties played hardly any role. If necessary, the sovereign even expressly overrode the self-imposed maximum wage taxes. The effective consequences differed according to sector qualification and prevailing circumstances. In economic terms, this can be described as the effect of supply and demand markets. In my study of Frankfurt am Main, but also beyond, it can be seen that the possibilities for negotiation became fewer during the early modern period. The main subjects of negotiation had been contract duration and salary, so this graph, which comprehensively depicts contract changes, give a good impression. In the 18th century, employers were less and less willing to engage in wage negotiations for a variety of reasons. Poor financial situations were met with cuts in personnel costs. The self-confident citizens demanded transparency and cost containment. Frankfurt could no longer create posts at will or freely negotiate paid because civil unrest had led to an imperial crackdown, and the establishment plan and salaries were now dictated by the court in Vienna. Changes to the contracts were now mainly due to external influences such as the imperial directives. And this is also included the abolition of variable remuneration components and the higher rating of a fixed salary. It was no longer the office but the state that maintained the civil servant, who at the same time became more dependent. This can also be seen in the development of the contractual income components over time. Early modern remnants of the old negotiation structure can be observed in the supplication system. With such petitions, the servants asked for adjustment of their salary, often through additional benefits in kind besides the salary, and in return for additional services voluntarily rendered. Such grants could result in regular annual supplements, which were then granted habitually, leaving the public servant without legal entitlement. When Frankfurt could no longer change the salary itself, the public servants appealed directly to the Reichshofrat in Vienna, one of the highest courts of the Holy Roman Empire. Forms of exploitation can be found in the early modern adjunct system. In the background are the civil servant dynasties, which today are discredited, among other things, as a sign of lack of social mobility. Before the introduction of fixed retirement salaries and age limits, civil servants worked until the end of their lives. Friedrich Wilhelm I calculated that he would rather keep the civil servants in service than pay them pensions, and formulated, "To death, one must feed them after all." In this way, he was able to absorb any remaining manpower. The contracts of the successors who were announced speak of the die-off of the former civil servant, which was awaited or desired from the successor's point of view. The replacement of fixed-term contracts by lifetime appointments meant that those incapable of a service continued to be provided for by their office, and if the employer decided not to terminate the contract. The work had to be done by the successor from B, who was often not or hardly paid for it and shared any official income with the former civil servant, while the latter kept his salary and, if necessary, his official residence. Similar solutions are known from the semi-private midwifery sector. Since this situation meant not only precarious employment, but in any case a wage below the subsistence level, one either had to bring some capital reserves to overcome the waiting period or join the father's service as a son and adjunct, thus securing the family income through the father's salary for the son's work. In lucrative professions, highly qualified men could also be secure their livelihood through secondary employment. However, a solid legal position was not yet archived in this way. There's evidence of cases in which the son rapidly petitioned for the transfer of office over a period of many years. The employer then profited from the father's remaining manpower and the son's unpaid and highly motivated work. Ultimately, the risk of poverty shifted from the end of the career to the beginning of the career. In a mitigated form, this shift can also be seen in modern times from the point of view of performance equity. Seniority steps and experience promotions have therefore been criticized for a long time. The modern civil service no longer knows forms of individual wage negotiation apart from a few marginal areas. Around 1800, legal doctrine developed the so-called alimentation principle, which on the one hand systematically combined all the developments and practice, for example, lifetime employment and fixed salaries instead of temporary contracts and mixed income, but also set new accents. The salary was not understood as remuneration, but as a lifelong maintenance pension. Jurists and economists argued intensively about the understanding of alimentation from the 19th century until the 1960s. The dispute has not been overcome to this day. Many authors understood civil service to be official duty that could not be paid but compensated for as damage. It was no longer a question of a negotiable wage, but a compensation for losses. Johann Michael Seufert was the first to coin this view, legitimizing alimentation beyond the end of service. The real founder, however, is Nikolaus Thaddeus von Gönner, whom the civil service law literature elevated to not only the decisive mastermind of the idea of alimentation, but to the father of civil service law, par excellence, because of his this so-called historical deed. For him too, the salary of civil servants was justified by legal concept of the claim to compensation, Aufopferungsanspruch. Unlike other jurists, however, he did not argue with the duty of service, but on the contrary referred to the fact that a civil servant, beyond his civic duties, contributed to the function of the state through the use of all his powers, and therefore also he was not entitled to a salary, he was entitled to a substitute substance income, Ersatznahrungsstand, for the lost income from another profession. For the question of asymmetrical dependence, the justification for the alimentation is interesting. Civil servants were maintained because they could not otherwise earn their remuneration, since administrative work outside the public sector on a larger scale was still unusual. This eventually changed with the rise of the tertiary sector. Initially, the state effectively held a monopoly on the demand for the work of special trained civil servants. The sharp critic of the alimentation system, Otto Meyer, formulated it vividly in 1924. Civil servants are not paid for what they perform, but for that what they can no longer perform. It was ultimately the theory of the special relationship of subordination that completed the exclusive classification of the civil servant relationship in public law. Gönner already tried to justify permanency and lifelong remuneration with the loss of the ability to earn another income. One can now draw up a genealogy of alimentation thinking, which I will forego for lack of time. Important supporters after Gönner were, for example, Georg Friedrich Hegel, Lorenz von Stein, Rudolf von Jhering, and Konrad Bornhardt. The latter clearly formulated that civil service law only knew duties, not rights, of the civil servant, since there could be no subjective rights vis-à-vis the state, so that the salary could only be paid as an act of mercy without legal entitlement. This orthodox view of the principle of limitation was still held until the 1960s. In 1963, for example, Wilhelm Werdenbruch described the salary as a loyalty gift, to which one was only entitled by statute and which was a secondary consequence of one's official duty. The Federal Constitutional Court turned away from this in the 1960s when it considered the pension claims of former soldiers of the Wehrmacht to be protected by the right to property under Article 14 of the German Constitution. Since then, scholars and legal practitioners have struggled to find a mediating understanding between the idea of wakes and the principle of limitation. And the origin and history of the principle of limitation from the perspective of fair wakes is a rather complex field, which my next book, if I can write it, will deal with. At this point, I will only briefly touch on the effects in the 20th century. The wake setting mechanism itself is already an expression of existing strong asymmetries, namely the possibility for the state to unilaterally set rights and obligations in the civil servant relationship, and thus, if we want to think in terms of contract law, so unilaterally change the equivalence relation of performance and consideration. It is common knowledge that German civil servants do not have the right to strike, which distinguishes them from civil servants in other European countries, most of them who limit the ban on strikes, if they have one at all, to particular groups of civil servants in the security and justice sectors. The effects of the absence of collective bargaining are significant. In the 20th century, the state also made use of its wage-setting competence in form of wage cuts. Pay policy was and is also budgetary policy. In 1909, an Imperial Salary Act was introduced for the first time because the stagnation of nominal wages for civil servants had led to a massive loss of purchasing power. And the aim was to make up for the gap vis-à-vis workers and craftsmen. The social decline can already be seen in the income statistics from 1850 onwards. Towards the end of the First World War, the salary of a Prussian senior official was below that of a peace worker. In the literature, the income gap was legitimized by the honor associated with civil service. Towards the end of 1923, real salaries fell to 33 to 59% of the pre-war level, which led to great indebtedness among the civil service. The solution only improved briefly in 1927. During the world economic crisis, income tax supplements and direct salary cuts for civil servants of about 20% in total were justified on the grounds of job security. Franz von Papen's government set up another special tax on civil servants for the benefit of unemployment insurance. These special sacrifices were punished with a surge of disloyalty by civil servants to the Weimar Republic and a greater willingness to embrace National Socialism. It was Carl Schmitt in particular who emphatically argued that the protection of the acquired rights of civil servants in the Weimar Republic was not a fundamental right, and that salaries should therefore be restricted by simple legislation. He polemicized against an understanding of civil servants' fundamental rights as an individualistic end in itself. The Imperial Fiscal Code, Reichsfinanzhof, followed this view, unlike the Imperial Court Reichsgericht, which nevertheless overturned the non-declaration of salary reductions by various higher courts in Bavaria, Dresden, and Danzig, because of the amendment reservations of the salary legislation. In 1933, as part of the Gleichschaltung, the National Socialists obliged the federal states and municipalities to pay their civil servants on the lower level of the German Reich. Salaries were not increased until 1938, but remained below the level of 1927. After the end of the Second World War, the economic situation of civil servants remained very poor, and attempts were made to alleviate the immediate hardship with allowances. In 1958, the purchasing power of the lower salary groups was still below the level of 1913. In the 1960s, civil servant salaries became more dynamic, but further development followed economic fluctuations. In the mid-80s, adjustments became urgent in the lower segment because some of the salaries were at the level of social welfare, so that the question of a minimum gap between social welfare and civil servant salaries became more central. Legal dogmatics are supported in the scarcity of alimentation. The principle of lifetime and the principle of alimentation became the main vehicles of continued dependency by contributing to the understanding of the civil servant relationship not as a principally time limit employment relationship and not as a contractual relationship about specific activities as the liberal service contract law of the Civil Code of 1900 did. Rather, it conceived of a lifelong loyalty relationship with an obligation on the part of the civil servant to place his or her entire personality in the service of the state. The civil servant relationship was the counter-model of the Civil Code, which specifically did not want to allow any subordination to an employer, any obligation to use on entire working capacity, and certainly no extension to the employee's entire personality. The salary was therefore designed to create dependency in the long term. The so-called hand-to-mouth principle was intended to ensure that civil servants were fed in the sense of a lifestyle in keeping with their status, although it was debated for a long time whether this meant more than just the most basic subsistence. On the other hand, it was not intended to make it possible to build up one's own assets, not even for old age. Rather, the old age pension is paid as so-called late wage after reaching the retirement age. By shifting the pay to the end of the life, strong lock-in effects are created. Secondary employment restrictions also support this effect. Today, of course, this is also loosened by post-employment insurance in the social security system, but the idea of a permanent lifetime commitment certainly persists and is reinforced by the fundamental qualification problem as an obstacle to switching to the private sector. The civil servant's pension thus sweetens the dependency created by previous austerity and ensures loyalty and also duties even in retirement. A comprehensive discussion of the problem of freedom in the service relationship would require at last one lecture of its own. I must therefore concentrate on two aspects that can be separated from each other. On the one hand, a freedom to enter into the service relationship. On the other hand, freedom to terminate it. Barriers to freedom in the ongoing employment relationship are also a recurring theme. I have and will address some of these issues elsewhere. Disciplinary law, the ban on strikes, the analytical imposition of rights and duties, the exclusion of legal recourse, contractual penalties, and other instruments of social discipline in the old empire. And the off-duty duties of good conduct, as illustrated by the Tinder ruling, were reflected in the late Middle Ages in the ban on attending parties, especially wedding parties, without sovereign permission. In addition, of course, there were also political duties of loyalty, but now I want to focus on the beginning and the end of service. In the Middle Ages, entering into an employment relationship with a sovereign was based on contract and a free decision. Unlike in otherwise bound private law, there was an exceptional area with freedom of contract. For lawyers, freedom of contract means the element of freedom of conclusion, including the choice of partner, freedom of form of the contract, and freedom of content. The former and the latter are interest in the presented context. Freedom of contract and choice of partner existed and clearly distinguished the pre-modern civil service relationship from contractual relationships with obligation to contract or even forms of unfree labor up to forced labor. And there was also freedom to negotiate the content, which is obviously on a theoretical level from the fact that one of the contracting parties acted as sovereign and could change the particular law. Although the scope of for negotiation was reduced in the early modern period, this was due to external effects and does not prove any disruption of the negotiation parity at the time of the signing of the contract. In terms of content, the city increasingly enforced the terms of the contract which led to an asymmetrical dependency of city employees, which can be described as strong in the terminology of the center. I will talk about different degrees and stages of development in more detail in September. For today, the basic structures are sufficient. The legal instruments were the duration of the contract and the termination regime. On the slide, you can see the share of fixed-term contracts for the respective period in Frankfurt. One-sided onerous contract conditions were relatively unproblematic with regard to the establishment of strong dependencies as long as the employment relationship were fixed-term duration. The end of the term was an exit and negotiation opportunity at the same time. Civil servants could negotiate better conditions or leave the employment. Contract extensions regularly led to higher pay, and the longer the contract period, the better the compensation, because the next negotiation opportunity was postponed further into the future. Making the contracts permanent deprived the employees of these individual bargaining opportunities, and there were no collective ones. The city no longer had to negotiate. What remained were the supplications, which, however, are precisely the hallmarks of asymmetrical dependency, because the supplication is made without a legal claim from a subordinate position and is not linked to any means of pressure. This connection is forgotten today with regard to other legal factors, but a German social democracy was still fighting against open-ended employment contracts around 1900. Legal norms are often only to be understood in interaction with each other, and this, of course, also applies to contract rights. The decisive variable for the effect of fixed-term and permanent employment is to be found in the law on the termination of contracts. It depends on who is allowed to terminate the employment relationship and under what conditions. From the perspective of both employees and civil servants, we are accustomed to the fact that the employee or civil servant can terminate the employment relationship, but the state generally cannot. And if the employment protection legislation applies, the private employer can only do with great difficulty. In the late Middle Ages and early modern period, the right to terminate employment in the civil service was usually unilateral on the part of the employer. The civil servants were therefore bound unilaterally by the permanent employment, while the employer could terminate the employment without difficulty and at most had to respect the notice periods, which were usually 4 weeks or 3 months. In the execution of the contract, the boundaries to unfree labor are blurred because the employee had no exit option without the employer's explicit consent. As far as I can see in the courts, were not disturbed by the permanent commitment. Conflicts over this tie were not uncommon. Civil servants wanted their service terminated, especially when they wanted to leave the territory, for example, because of marriage or inheritance, or also because they had a better offer. In Frankfurt, the council often agreed as soon as the servant could present a suitable successor, but the risk was passed on to the servant. In the 17th and 18th centuries, however, there was a dispute about the legal effectiveness of the public employer's free right to terminate employment. The files of the Reichshofrat contain serious conflicts. Duke Franz II of Sachsen-Lauenburg accused a former high official, Dr. Hector von Mithoff, the elder, of unauthorized desertion and withheld his annual salary and other assets. Allegedly, Mithoff had left the service 1 day too early, while Mithoff argued that the contract had expired. The dispute from 1616 widened because Hanover also intervened, whose syndic and citizen Mithoff was, and which now saw its imperial law privileges violated because of the action against the Hanoverian citizen. The background to the conflict was that Franz II had given Mithoff a house as a gift on the occasion of the last extension of his contract, an investment that was now in danger of being lost. The case demonstrates both extreme success in negotiating the renewal of a contract as well as conflicts over the ending of a contract that in this case was even limited in time. For the thinkers of civil service law around 1800, however, the civil service relationship was no longer based solely on a free agreement of will between the parties, and thus on a contractual basis. Rather, the civil servant was merely fulfilling his official duty to the state so that a basis in contract law was necessary and applicable. This seems to me, nevertheless, to be a rather theoretical construction with possibly further legal consequences in the performance of the contract. Forced service works very poorly in the civil service systems. The state is too dependent on the loyal conduct of qualified officials. However, civil service and personal unfreedom have traditionally not been mutually exclusive. In the Roman civil servant slaves, or in the still unfree ministerials of the Middle Age, some of whom were even lower nobles, we find a long line of tradition with which other participants are presumably more familiar. In the early modern period, when attempts were made to give a more concrete legal definition to the civil servant relationship and to determine the type of contract, the Roman locatio conductio operarum was used in addition to mandatum and precarium. It was originally oriented on the rent in kind of slaves as a service, a rent of freemen, especially as day laborers. Here we find another parallel to the servant relationship Gesindeverhältnis, which was classified in the same way. In addition to practical reasons, there are also countervailing changes in legal thinking that prevented the civil service relationship from turning into an involuntary one and strengthened the civil servants' right to terminate their employment. I'm talking about the idea that freedom must be also non-waivable, meaning that one must not place oneself in slavery, debt, bondage, or a lifetime commitment. The idea established itself in German legal thought not until the end of the 18th century, more precisely the so-called younger natural law, which, unlike the older one, no longer legitimized sovereignty. Dieter Klippel's famous study on political freedom and liberties in 18th century German natural law from 1976 examined this more closely and locates this turning point in the late German reception of John Locke's work from around 1780. That this really made a difference can perhaps be supported by a late medieval case example from Frankfurt. In 1497, the mounted mercenary, Reisige, Heinz Wisport, had lost his horse. In order to be able to fulfill the service requirement of being mounted, the council gave him 24 guilders to buy a horse. In return, he bound himself to the city for life. He was not allowed to resign for the rest of his life, while the city had the right to terminate his contract at any time without notice. Other reasons for a lifetime commitment were, for example, study scholarship of salary supplements or salary supplements. Lifetime commitments for pay was a model that could therefore occur in different contexts. The question, who decides conflicts, is of course central to the issue of asymmetric dependency. The keywords are quickly recounted: existence of an independent judiciary, lack of jurisdiction and legal recourse, fundamental rights to effective legal protection. Historically, this is already problematic in the private sphere. I would only remind you of the patrimonial jurisdiction of the landlords, for instance, also over the servants. In the state sphere, the conflicts are already virulent at the starting point. The problem is not limited to influencing judges or extreme cases of cabinet justice in which a ruler arrogates the final decision-making authority. Rather, before the establishment of a separation of powers, the employer could simply be the competent judge over these legal disputes. In Frankfurt, the council was the highest court in various formations, sometimes with, sometimes without its guild representatives, and therefore judge and employer in personal union. Effective legal protection therefore required the possibility of appeal to the imperial jurisdiction. Various territorial rulers had privileges that precluded this so-called privilegia de non appellando. Even if the emperor had not granted them such privileges, the territorial and municipal lords nevertheless tried to cut off legal recourse by having the officials sign jurisdiction clauses that exclude appeal to the imperial courts. The slide shows the occurrence of jurisdiction limiting clauses in the Frankfurt Letters of Service. Attempts to disregard these jurisdiction clauses could quickly escalate. For example, between 1709 and 1711, Duke Eberhard Ludwig of Württemberg reacted to an appeal to the Reichshofrat by his Oberrat and Rentkammerprokurator Jung with imprisonment for violation at the oath of service. The case concerned an unwanted forced retirement on particularly poor retirement terms, whereas the Duke claimed an arbitrary right of dismissal and therefore described complaints about a low pension as ungrateful, spiteful, and rapacious because he saw an act of mercy in the benefit at all. As a result, Jung waived further litigation for his release and moved on to seek other employment. Something similar happened in 5080 to the former court butcher and kitchener Stefan Röselmeier and his legal advisor, the Salzburg lawyer Dr. Albert Lorenz, who took legal action before the Reichshofrat against Röselmeier's former employer, the Prince Provost Jakob von Berchtesgaden, because the latter did not want to pay 5 years outstanding salary and did not want to give a certificate of service. Out of poverty, the plaintiff initially did not institute legal proceedings but interceded with the Archbishop of Salzburg. He and his advocate then both faced dangers for life and limb. The complaints appear credible because other former civil servants also sued Jacob for threatened or excused reprisals in response to demands for payments of rates. In very modern terms, the clergyman, who was only directly subordinate to the Pope, probably sent out thugs to intimidate his creditors and, if necessary, do even more. So it was not only higher officials who appealed to the imperial courts. In the files of the Reichshofrat, I also found, for example, a chancery clerk, advisor, a cellarer, a forestry servant, a sub-customs officer, a weight master, a trumpeter of junk. Nevertheless, legal action was costly, uncertain, and dangerous, which is why officials often limited themselves into interterritorial options. In addition to the less promising advisory lawsuit against the employer, this was the supplique, which, however, manifested and perpetuated the relation of subordination. Let me conclude with a case study that shows that it is not about complaining on a high level. In 1670, the Hanau-Lichtenberg councillors Lohse and Seufert requested protection in a dispute with their employer. In a serious constitutional conflict, they had recommended a different course of action than the one chosen and had been dismissed as a result. In addition, they were threatened with further reprisals in the form of withheld salaries and threats of punishment. They themselves had managed to escape, but their wives were arrested while heavily pregnant or out of childbirth. While the wife was giving birth in the prison, the names of the councillors were hammered on the gallows and effigies were made to symbolically decapitate them. To my knowledge, the legal conflicts surrounding the civil servant relationship in the 19th and 20th century have not been intensively researched in legal history. But I would like to point out that a solution of the procedural problems did not at the same time mean a solution to the questions related to substantive law. For example, the validity of fundamental rights in the special relationship of subordination. The trial on salary cuts for civil servants before the imperial court, Reichsgericht, which I spoke about earlier, was one of the sensational lawsuits of the Weimar Republic. The Reichsgericht answered the question in the negative as to whether the protection of the vested rights of civil servants in Article 129 of the Weimar Reich Constitution secured the level of pay that had even been reached. Because the reservation of the right to change the pay legislation meant that the corresponding pay could not become the vested right. Even if Article 129 explicitly opened legal recourse to civil servants for property claims, the Constitution did not prevent the employer and legislator from unilaterally reducing the remuneration insofar as he reserved the right to do so. From a legal and legal historical perspective, I have, in my opinion, shown characteristic features of symmetries and dependencies in the public service relationship, also in their differences to the private sector. Are these asymmetries now strong? Let me formulate a few theses on this, which we can, of course, discuss controversially afterwards. Dependency in the civil service was first constructed by contract, later by legislation. Entry into public service in the late Middle Ages and early modern period was based on free contracting, was in practice virtually the prototype of a free employment contract. Legal doctrine at the transition to the modern era took a different view, constructing state service as a civic duty and departing from the idea of a free service contract with freely negotiated rights and duties. Although entering and remaining in civil service no longer had to be based on a free will decision by the civil servant, the use of direct coercion was hardly conceivable. Conversely, the de facto state dependence on a loyal bureaucracy was too great. This did not have to be tested because of the sufficient number of volunteers available at last in modern times. But once in service, the terms of the contract could create one-sided dependencies. They are expressed through duties of loyalty and obedience, disciplinary power, and an encroachment on the civil servants' private lives, which is now usually determined by the legislature, whereas the older system was based on individual negotiation. Dependence became particularly strong when exit and protest opportunities were taken away by limiting legal resource and lifetime commitment. The more recent concept of natural rights, which expressed in the fundamental rights catalogues of the constitutions or also in the sub-constitutional codifications, prevented this. The special relationship of subordination, of course, sets limits to these ideas of freedom. The narrative of a development from unfree to free labor does not apply to the civil service for several reasons. Firstly, the older civil service cannot be characterized as unfree labor, but stood as a prototype for the free service contract. Secondly, the civil service relationship developed from a contractual relationship to a status relationship in which dependency was no longer negotiated, but set ex ante by the employer. Thirdly, constitutional law doctrine and practice delayed the implementation of the principle of freedom in the civil servant-state relationship through the construction of the special relationship of subordination. Under the rule of the German Constitution, this was regarded as an imposition, which is why fundamental rights now also apply in the civil servants relationship. Fourthly, the construction of dependency is therefore more subtle today. For example, through the elaboration of the principle of alimentation with this pension system, and more on a de facto level, for example, because of the limited alternatives due to specialization. Here, of course, one would have to distinguish more precisely. The circumstances of the various professions and career classes are too different. I will skip the third point because it's more interesting for jurists alone. Separation of asymmetric dependency and social status. I think that's the main point. Even though German civil servants have not been particularly high earners over long periods of time, it is difficult to perceive them as an underprivileged group. This also means that asymmetric dependency does not necessarily correlate with socioeconomic status, education, origin or lack of social capital. Civil servants may not always have had an adequate income, but at last had a regular and secure one. The level of education and qualification varied according to position, but the legal dependency did not change even for the most highly qualified civil servants. Migration and foreignness are relevant to the civil service in a completely different sense, namely as a barrier to entry and a mechanism of exclusion when citizenship or at the local level even indigeneity was required for entry into the civil service. Such a restriction was brought about by the transition from the late Middle Ages to the early modern period. Access to the ruling elite existed in the higher positions anyway, but even subaltern civil servants are not only understood the use of family networks and other social contracts, which may even have to provide guarantees for the transfer of office, but also knew about the legal way to make their voices heard as far as this was legally possible. And my last point, although civil service law was characterized by some strong asymmetrical dependencies, there were always enough volunteers who wanted to enter into it. Obviously, people wanted to enter into dependency or at last accepted it in a view of the accompanying advantages, namely a certain security and protection. It is not without reason that commendatio, the protective subjection of the vassal to his liege lord, is also part of the historical tradition of civil service. This appeal also applies to modern system of pensions, which seem to sweeten the dependency. Thank you very much for your attention and patience.